Hi, everybody. Welcome back to Patriots History of the United States. We just finished up the American Revolution, and we are about to embark on the period leading up to the American Constitution with the Articles of Confederation. And so this is the last time we started chapter 4. This is chapter 4, A Nation of Law. And today we will start with the subheader, Chaos and Patriots to the Rescue, on page 100. Now, a reminder, I am using the 15th anniversary edition of Patriots History of the United States. If you are using an earlier edition, some of the pages may not match, but the headers should always match. So you ought to be able to find Chaos and Patriots to the Rescue in any edition or any printing of the book. Another reminder that we are trying to turn Patriots history into a video series, and I need your help to do that. If you would go to the wildworldofhistory.com and look at the Buy Larry a Coffee button, where you can watch the trailer for the series we have in mind, a John Adams Sons of Liberty type series. And if you like the trailer, and you will, because it's a fantastic trailer, buy me a coffee. Buy me 5 coffees. I've had people buy me 300 or 400 or 500 copies because they believe in the project that much. And we are marching toward a goal of funding this through crowdfunding. So help out. Also a reminder, there's tons of free stuff on the Wild World of History website. Poke around a little bit, look in the blogs, but you will find tons of free articles, maybe 40 or so that I've written on everything from was Prohibition really unpopular to the Winged Hussars, the Charge of the Winged Hussars, to Custer's Last Stand. I mean, everything's in there. So take a look around there. And then a final reminder is I am working on an update, what essentially would be the 6th edition or the 20th anniversary edition of Patriots History. I hope to have that up later this summer. I keep finding great new research that I need to include, but we will make that freely available on the web as a media asset. And so you won't need to buy a new book. You'll be able to just download that free. And it will also have added material, upgrades, insertions, expansions on earlier sections in the book, not just material from 2018 to 2023, which it will have, but it will also have other material. So keep your eyes posted. Let's see, a couple other housekeeping notes. I published my autobiography, The Rhythm of History, this past week. If you're interested, look at the Wild World of History and the Wild World of Politics and see how you can get a copy. We have some excerpts available up there. And we're entering homeschool season this week. I will not be here on Friday because I will be at the California Homeschool. So if you're in California, I hope to see you out there at the Great Homeschool Convention in Ontario. All right, let's get started. So Chaos and Patriots to the Rescue, page 100 of Patriots History of the United States. The standard fare for most 20th century high school and college texts expressed the view that the Articles of Confederation period constituted a, quote, critical period, unquote, during which America experienced a precarious brush with anarchy. Indeed, problems plagued the young nation. The economy plummeted and crowds rioted, with Shays' Rebellion in 1786 epitomizing the new nation's problems stemming from the Articles. This pre-constitution that governed the nation from 1783 to 87 proved ill-suited. Let's see where, I'm sorry, I'm lost my train of thought here. There, proved ill-suited to organizing the country, leaving the Confederation Congress bankrupt, corrupt, and inept, a body that bungled domestic affairs and drifted into weakness against foreign powers. Then, remember, this is the story that you read. Then, according to this story, a band of heroes galloped to the rescue. Washington, Hamilton, Jay, Franklin, and others called the 1787 Philadelphia Convention and wrote the Constitution, lifting the endangered nation out of its morass and providing a sensible governing framework. These founders saved America from ruin and established a system of government that endured to the present day. Unfortunately, little of this interpretation is accurate. Historian Merrill Jensen especially spent much of his career debunking what he called the, quote, myth of the Confederation era. Like all good stories, the Chaos and Patriots to the Rescue interpretation contains certain elements of truth. Certainly, Confederation governmental institutions did not provide all the answers to the new nation's most pressing problems, and some of the story, no doubt, was driven by the partisan political viewpoint of the early historians, who tended to glorify the role of the founders. 1780s, in fact, witnessed a division of the early Whigs into factions that strongly disagreed over the course that the new nation would follow. Nationalists, later called Federalists, cried anarchy, while others, later known as anti-federalists or Jeffersonian Republicans, pointed to the successes of the Confederation government and noted that, among its other accomplishments, it had waged a war against and defeated Great Britain, the greatest military power on earth. So, which historical view is correct? Although historians continue to debate the successes of the Articles of Confederation, matters become clearer if it is approached as a document it was, namely the first Constitution. Even dating the Articles, though, is difficult. Although not legally adopted until 1781, Congress, in fact, functioned within the framework of the Articles from the time of its drafting in 1777. To make matters more complex, the First and Second Continental Congresses of 1774 and 1775 operated under a system exactly like the one proposed in 1777. Therefore, realistically, the United States was governed under the Articles of Confederation from the time of the Declaration of Independence until Washington was inaugurated as the first president of the United States under the Federal Constitution of March 1789. While the Continental Congress developed a structure for running the colony's affairs during the early part of the Revolution, it remained informal until 3 weeks prior to the Declaration of Independence, at which time the states sought to formalize the arrangements through a government that would fight the war while simultaneously leaving to the individual states most of their powers and prerogatives. On June 12, 1776, Congress appointed a committee with one representative from each state to draft such a constitution. Headed by the Pennsylvania farmer John Dickinson, whom we've heard of before, the committee 1 month later presented a draft of the Articles of Confederation, given its name by another committee member, Benjamin Franklin. Objections to the new plan surfaced quickly and immediately drifted into territory that many delegates had avoided, the issue of slavery. The heavily populated areas protested the fact that each state had an equal vote in Congress, akin to today's United States Senate, where every state has 2 votes. But the more lightly populated southern colonies had different concerns involving the counting of slaves for representation in a body determined by population, such as today's House of Representatives. Perhaps more important at the time, however, the states disagreed over what is often referred to as public domain. Several of the 13 states possessed sea-to-sea charters that claimed lands within the parallels stretching from the Atlantic to the Pacific Ocean. These were the so-called landed states, Virginia, Carolinas, Georgia, and others, as opposed to the landless states, Maryland, Delaware, New Jersey, which insisted that the landed states relinquish all of their claims west of the Appalachian Crest to the Confederation as a whole. Ultimately, the parties agreed to postpone the discussion until after the ratification of the Articles of Confederation in 1781. But it raised the question of charters and grants in a broad sense. Was a charter from the king an inviolable contract? If so, did England's grip on the colonies remain even after independence? If not, were all pre-independence contracts null and void? There's going to be a court case before too long involving Dartmouth College. And if such contracts are void, what did that say about property rights? That they only existed after the new nation was born? Congress, meanwhile, continued to operate under the terms of the unratified articles throughout 1776 and 1778 period, becoming one of the most successful revolutionary legislatures in the history of Western civilization. In retrospect, the articles created a remarkably weak central government precisely because that was what the radical Whigs wanted. Not surprisingly, the Whigs, who had battled royal governors and a king for 7 years, did not leap to place power in the hands of a new chief executive in 1777, and the same logic applied to the courts, which Whigs assumed functioned at best at the state, not national, level. There was provision in the Articles for congressional litigation of interstate disputes, but it proved ineffective. That left only the legislative branch of government at the national level, which is exactly how the Whigs wanted it. Their definition of federalism differed significantly from the one taught in modern political science class. Federalism meant a system of parallel governments, state, local, national, each with specified powers, but sovereignty ultimately rested in the states and, by implication, the people themselves. Whigs saw this as completely different from nationalism, which divided power among the same three levels, state, local, and national, but with the national government retaining the ultimate authority. This later model appeared after the Federal Constitution of 1787, but a decade earlier, anyone who called himself a Federalist embraced the decentralized Confederation model. Okay, get that? I'll come back to that. Not that of a sovereign centralized state. In this way, the Articles preceded, or more appropriately instigated, a raucous debate over the federalism of the American Revolution. After independence, delegates to Congress changed the name of that body from the Continental Congress to the Confederation Congress. The number of delegates each state had sent had varied throughout the war, from 2 to 7 per state, although each state retained one vote cast according to the majority of its congressmen. This aspect of the Confederation seemed to lend credibility to the argument that the nation was merely an affiliation of states, not a united American people. But other sections appeared to operate on different assumptions. A 7-state majority could pass most laws, but only a 9-state vote could declare war and ratify treaties, clauses that challenged the contention that the states were sovereign. After all, if states were sovereign, how could even a vote of 12 of them, let alone 9, could commit all to war? Interestingly, Thomas Jefferson, in commentaries leading up to the Land Ordinance of 1785, called for, quote, cultivating the idea of our being one nation, and to multiply the instances in which people shall look up to Congress as their head, emphasis ours. The schizophrenic nature of some of these provisions came to a head in the amendment clause, where 13 votes, unanimous agreement, were needed to amend the articles themselves. Given the nature of the revolutionary state politics, this stipulation rendered certain provisions of the articles, for all intents and purposes, invulnerable to the amendment process. Congressmen wrote all the national laws and executed them through a series of congressional committees, including foreign affairs, war, finance, post office, and so on. Congress possessed limited fundamental powers. Only Congress could conduct diplomacy, make treaties, and declare war. It could coin and borrow money, deliver mail through a national post office, and set a uniform standard of weights and measures. Very important. As part of its diplomatic charge, Congress dealt with the Indian tribes, negotiated treaties with them, and created a national Indian policy. And when a national domain came into being in 1781, Congress had exclusive charge to legislate policies for land sales and territorial government, as it turned out, one of its most important powers. These powers put Congress on sound footing. But in true Whig fashion, the Articles of Confederation saved many important prerogatives for the states and the people. For example, Congress could not only requisition money and soldiers from the states, thus leaving true taxation and military power at the local level. This taxation provision meant Congress could not regulate commerce through import and export duties. So the Confederation Congress was a true Whig government, which had its economic and military arm tied behind its back. As Article 2 of the Articles of Confederation stated clearly, and the 10th Amendment in the Constitution would later reiterate, quote, each state retains its sovereignty, freedom, and independence in every power, jurisdiction, and right, which is not by this Confederation delegated to the United States in Congress assembled. So why don't we take a minute here and read the Articles of Confederation. And so this is in the Patriots History Reader, Chapter 6, the Articles of Confederation and Perpetual Union. And it'll be a long one. First national governing document for the newly freed colonies, the Articles of Confederation, was written by John Dickinson of Pennsylvania in July 1777. It underwent a number of revisions, being adopted in November. Its ratification by all the states, which was required before the Articles could go into effect, did not take place till 1781. Although frequently maligned by American historians throughout the years as an ineffective national constitution, this document and the government functioning under its articles did have some successes, such as winning the Revolutionary War and producing both the Land Ordinance, which I maintain is the most important law in American history, and the Northwest Ordinance. Its form reflected the experience of the colonial legislatures, and neither the executive branch nor the judiciary was structured sufficiently well to handle the pressing problems that arose after the war ended and the Treaty of Paris was signed. The Articles established the government as a confederation with a president elected by Congress to serve a term of 1 year and ineligible to serve more than 1 year out of 3. Throughout, it reflects the English Whig view that the legislature was the dominant branch of government and the executive branch was weak and even subservient to the legislature. Without leadership from an effective executive branch, the new nation's political process rapidly bogged down in spite of the best efforts of the state governments and the Congress. But a majority in Congress probably thought the Articles needed only to be modified to make the government stronger without sacrificing the principles of Confederation. Others, notably James Madison, Alexander Hamilton, recognized that a major overhaul was necessary and that a federal government was needed if the fledgling country was to survive. Ultimately, the U.S. Constitution replaced the Articles in 1788, but not without a fight. The idea of a confederation of sovereign states was cherished by those who saw the sectional differences as requiring strong local governments, much like those in Switzerland. However, confederations had proved to be workable only in small countries that did not play major roles in international affairs and can resist or avoid aggressive nations due to special circumstances. Think Switzerland, which is surrounded by very, very difficult to pass mountains. The United States harbored potentially as a great power with vast resources, making a strong executive branch a necessity. The Articles would have perpetuated slavery long past its acceptance internationally, and it is doubtful that making minor changes in the Articles would have enabled the United States to survive and become an exceptional nation. And we'll have more of this debate as we get into the U.S. Constitution itself. Okay, the Articles of Confederation. To whom all these presents shall come, we, the undersigned delegates of these states, affixed our names, send greeting. Articles of Confederation, perpetual union between the states of New Hampshire, Massachusetts Bay, Rhode Island, Providence Plantations, Connecticut, New York, New Jersey, Pennsylvania, Delaware, Maryland, Virginia, North Carolina, South Carolina, and Georgia. Article 1, the style of this confederacy shall be, quote, the United States of America. Article 2, each state retains its sovereignty, freedom, and independence, and every power, jurisdiction, and right which is not by this Constitution, this Confederation, expressly delegated to the United States in Congress assembled. So if it doesn't say in the Articles, states, you lose this power to the Articles Congress, you keep it. Article 3, the said states hereby severally enter into a firm league of friendship with each other for their common defense, the security of their liberties, and their mutual and general welfare, binding themselves to assist each other against all force offered to or attacks made upon them or any of them on account of religion, sovereignty, trade, or any pretense whatsoever. All right, so notice this. Having just said in Article 2 that each state retains its sovereignty, Article 3 hereby commits all states to fight for all other states. It's a NATO type treaty. You attack one, you attack all. Article 4, to better secure and perpetuate mutual friendship and intercourse among the people of different states of this union, the free inhabitants of each of these states, paupers, vagabonds, and fugitives from justice excepted, shall be entitled to all privileges and immunities of free citizens in the several states, and the people of each state shall have free ingress and regress to and from any other state, and shall enjoy therein the privileges of trade and commerce, subject to the same duties, impositions, and restrictions as the inhabitants thereof, respectively, provided that such restrictions shall not extend so far as to prevent the removal of property imported into any state, i.e. slaves, to any other state of which the owner is an inhabitant, provided also that no imposition, duties, or restrictions shall be laid by any state on the property of the United States or either of them. In other words, New Jersey won't be able to tax South Carolina slaves if they bring slaves into New Jersey. If any person guilty or charged with treason, felony, or other high misdemeanor in any state shall flee from justice and be found in any of the United States, he shall, upon demand of the governor or executive power of the state from which he fled, be delivered up and removed for the state having jurisdiction of his office. Full faith and credit shall be given to each of these states to the records, acts, judicial proceedings of the courts and magistrates of every other state. This is a notion known as comity, C-O-M-I-T-Y, not comedy. And basically it says that today, one state will observe and recognize legally passed laws of another state insofar as is common. For example, marriage. You get married in Kentucky, your marriage certificate is valid in Pennsylvania. Divorce, you get divorced in New York, you're divorced in New Mexico. So things like that. Comity, that you recognize, you agree to recognize the laws of other states. Now, where this gets into problems is if you have one state like California that declares itself a sanctuary state and say, oh yeah, send us all your illegals, and the other states do that. And then California gets mad and says, well, we didn't want all your illegals. I mean, there's all sorts of problems like that. And eventually a lot of this has to be fixed through comity. Article 5, for the most convenient management of the general interest of the United States, delegates shall be annually appointed in such a manner as the legislatures of each state shall direct to meet in Congress on the first Monday in November in every year, with a power reserved to each state to recall its delegates or any of them at any time within the year, and to send others to their stead for the remainder of the year. No state shall be represented in Congress by less than 2, nor more than 7 members, and no person shall be capable of being a delegate for more than 3 years in any term of 6 years, nor shall any person being a delegate be capable of holding any office under the United States for which he or another for his benefit receives any salary, fees, or emolument of any kind. In other words, if you're a delegate from the state of New York, that's your only gig. You don't get to be part of the Articles of Confederation government. In determining questions, the United States in Congress assembled, each state shall have one vote. freedom of speech and debate on Congress shall not be impeached or questioned in any court or place out of Congress, and the members of Congress shall be protected in their persons from arrests or imprisonments during the time of their going to and from and attendance in Congress, except for treason, felony, or breach of the peace. The Article 6, no state shall, without the consent of the United States Congress assembled, send any embassy to or receive any embassy from or enter into any conference, agreement, alliance, or treaty with any king, prince, or state, nor shall any person holding any office or profit or trust under the United States or any of them accept any present emolument, office, or title of any kind from any king, prince, or foreign state. Can you say a $5 million bribe? Would that apply? Nor shall the United States in Congress assembled or any of them grant any title of nobility. So we have no nobility in the United States. No two or more states shall enter into any treaty, confederation, or alliance, whatever between them, without the consent of the United States in Congress assembled, specifying accurately the purposes for which the same is to be entered into and how long it shall continue. This continues with the Constitution. So the so-called compact of states that are saying, well, whoever wins the popular vote gets the electoral vote, which would always be a Democrat, because in recent times, the Democrats always win the popular vote. They just can't ever, not ever, but they can't always win the electoral college. So this is an attempt by Democrats to get around the electoral college and say, well, whoever wins the popular vote wins everything. A compact is invalid, unconstitutional, and not going to happen. So you say, why hasn't it been struck down? This goes back to the theory of ripeness in the Supreme Court, that a case has to be a real problem. It has to be an issue before the court will take it up. They don't take up hypotheticals. They don't take up stuff that isn't a problem yet. The compact's not a problem because enough states haven't ratified it and because it hasn't affected an election. They ratified it and it affected an election. Let's say somebody, let's say RFK Jr. won the popular vote in 2024, and we had this compact in place. But let's say Ron DeSantis won the electoral college. This would be invalid according to the court because the United States as a whole did not say, yes, you guys can have your compact. Sometimes it is worked out with trade compacts, but never on anything like this. No state shall lay any imports or imposts or duties which may interfere with any stipulations and treaties entered into by the United States in Congress assembled or with any king, prince, or state, and pursuant to any treaties already proposed by Congress to the courts of France and Spain. In other words, a state can't create taxes on items that the national government has already said we're not going to tax that. So let's say England is shipping wool into America and it's tax-free. The state of Montana can't come along and say, we're going to put a tax on wool. Can't do it. No vessel of war shall be kept up in time of peace by any state except such number only shall be deemed necessary by the United States and Congress assembled for the defense of such state or its trade, or shall any body of the forces be kept up in any state in any time of peace except such number only as in the judgment of the United States Congress assembled shall be deemed requisite to garrison the forts necessary for the defense of such state. But every state shall always keep up a well-regulated and disciplined militia sufficiently armed and accoutred, and shall provide and constantly have ready for use in public stores a due number of field pieces and tents. That would be cannons. So the states individually are supposed to be the equivalent of a national army, if you combine all the states, including cannons, and a proper quantity of arms, ammunition, and camp equipage. No state shall engage in any war without the consent of the United States in Congress assembled, unless such state be actually invaded by enemies, or shall have received certain advice of a resolution being formed by some nation of Indians to invade such state, and the danger is so imminent as to not admit of a delay till the United States Congress assembled can be consulted. Nor shall any state grant commissions to any ships or vessels of war, nor letters of marque and reprisal we'll talk about this more later in the Constitution, except it be after a declaration of war by the United States and Congress assembled, and then only against the kingdom or state and the subjects thereof, which war had been so declared, and under such regulations as shall be established by the United States and Congress assembled, unless a state be infested by pirates, in which case the vessels of war may be fitted out for such occasions and kept so long as the danger shall continue, or until the United States and Congress assembled shall determine otherwise. So you can't raise navies and go out and provoke wars with Britain or France or somebody else, hoping to draw in the rest of the country. You're not even permitted to have a navy, except that you might need it, say, in North Carolina, which was a haven for pirates, to fight piracy. Article 7, when land forces are raised by the state for the common defense, all officers of or under any rank of colonel shall be appointed by the legislature of each state respectively, by whom such forces shall be raised, or in such manner as such state shall direct, and all vacancies shall be filled up by the state which first made the appointment. So this starts a trend in which you have officer corps all the way up until the Civil War being named by the state legislatures. And this is a problem because they're usually politicians and not soldiers. And you get a lot of officers in the Civil War who are totally inept officers. And after the Civil War, this is replaced by a system of a professional army where you get people who are trained to fight, know how to fight, and aren't just out there for their hometown or whatnot, trying to get glory. Article 8, all charges of war and all other expenses shall be incurred for the common defense or for general welfare and allowed by the United States Congress assembled shall be defrayed out of a common treasury, which shall be supplied by the several states in proportion to the value of all land within each state, granted or surveyed for any person, as such land and such buildings or improvements thereon shall be estimated according to the mode as the United States in Congress assembled shall from time to time direct and appoint. The taxes for paying for the proportion shall be laid and levied by the authority and direction of the legislatures of the several states wherein the time agreed upon by the United States Congress assembled. So you see here, one of the big problems. You've got a war. You got to pay for a war, but the Articles of Confederation Congress itself can't tax anybody. It says, North Carolina, here's your tax bill, go collect it. South Carolina, here's yours, go collect it. Well, if that state isn't down for the war and they don't want to support it, they just simply won't collect the taxes. Article 9, United States in Congress assembled shall have the sole and exclusive right and power of determining on peace and war, except for the cases mentioned in the 6th article of sending and receiving ambassadors, entering into treaties and alliances, provided that no treaty of commerce shall be made whereby the legislative power of the respective states shall be restrained from imposing such imposts and duties on foreigners as their own people are subjected to, or from prohibiting the exportation or importation of any species of goods or commodities whatsoever, of establishing rules for deciding in all cases what captures on land and water shall be legal, and what manner prizes taken in land and naval forces in the service of the United States shall be divided or appropriated, of granting letters of marque and reprisal in times of peace, appointing courts for the trial of piracies and felonies committed on the high seas, and establishing courts for receiving and determining finally appeals in all cases of captures, provided that no member of Congress shall be appointed to judge in any of the courts. All right. So here's the deal on letters of marque and reprisal. Letter of marque and reprisal is granted by the legislative bodies or the Congress, not by the governors or the president. And basically, they sidestep the president in terms of declaring war. If a president does not want to declare war, Congress, without the president's authority, excuse me, can issue letters of marque and reprisal. Basically, these letters allow merchant seamen, sea ships, to arm themselves with no stipulations given as to how much armor they may carry. In theory, a merchant ship could be a well-armed cruiser Reprisal means if someone steals your cargo at sea, you have the right to go get it back. Indeed, the letters of marque can be quite specific and say specifically who the merchantmen are allowed to basically go to war with. So there's a really good novel about this some time ago. It was either by Vince Flynn or Kyle Mills. Can't remember which of the two, but it's centered around the use of letters of marque and reprisal. And it's a very interesting tool that I thought could have been used at various times in lieu of war. For example, now we have tankers. You may have seen the movie Captain Phillips with Tom Hanks. We have tankers that are in danger of being taken by pirates, Somali pirates and other pirates and so on and so forth. Well, Congress could issue a letter of marque and reprisal that would allow them to go get their tanker if taken, or would allow them to arm themselves in such a way so that pirates could never get them in the first place. It's a very interesting concept. I don't know that any other nation in the world has this in its constitution. So it's worth discussing. Okay, we're back in the reader on page 30 under Article 9, paragraph 2. The United States in Congress assembled shall also be the last resort as an appeal to all disputes and differences now subsisting or that hereafter may arise between two or more states concerning boundary, jurisdiction, or any other causes whatever, which authority shall always be exercised in the manner following. Whenever the legislative or executive authority or lawful agent of any state in controversy with another shall present a petition to Congress stating the matter in question and praying for a hearing, notice thereof shall be given by an order of Congress to the legislature or executive authority of another state in controversy, and a day assigned for the appearances of the parties by the lawful agents, who shall then be directed to appoint by joint consent commissioners or judges to constitute a court for hearing and determining the matter in question. But if they cannot agree, Congress shall name 3 persons out of each of the United States, and from the list such persons shall alternately strike out 1 petitioners beginning until the number shall be reduced to 13, and from that a number not less than 7 nor more than 9 names Congress shall direct shall in the presence of Congress be drawn out by lot as the persons whose names so drawn or any 5 of them shall be commissioners or judges to hear and finally determine the controversy. So always a major part of the judges who shall hear the case shall agree in the determination. And if either party shall neglect to attend to the day appointed without showing reasons which Congress shall judge sufficient, or being present shall refuse to strike, the Congress shall proceed to nominate 3 persons out of each state, and the Secretary of Congress shall strike in behalf of such party absent or refusing, and the judgment and sentence of the court to be appointed in the manner before prescribed and shall be final and conclusive. If any of the parties shall refuse to submit to the authority of such court or to appear to defend the claim or cause, the court shall nevertheless proceed to pronounce sentence or judgment, which shall in the manner be final and decisive. The judgment or sentence and other proceedings being in either case transmitted to the Congress and lodged among the acts of Congress for the security of the parties concerned, provided that every commissioner before he sits in judgment shall take an oath to be administered by one of the judges by the Supreme or Superior Court of the state where the cause shall be tried, quote, well and truly to hear and determine the matter in question according to the best of his judgment without favor, affection, or hope of reward, provided also that no state shall be deprived of territory for the benefit of the United States. It's interesting, and we're only, not even half done with this particular article. And we're going to stop with this one, pick up. But it's interesting, they spent so much time on land and boundary disputes because the Articles of Confederation Congress could see this was going to be a big issue with the landed and landless states. That was going to be the first issue. The second issue was going to be, okay, once you decide that, how are you going to decide the issue of the settlers moving out to these new areas and settling. Are they going to be citizens? What's going to happen with them? And so the boundary disputes were going to be a very big deal. And look at the almost insane levels they went to try and ensure a fair hearing that everybody would agree to. You're going to have this big pool of guys. They're going to select out of those 13. You're going to strike off ones that each side doesn't like. Then you're going to, it's almost like a court trial, right? A murder trial. And then you're going to end up with 5 to 9 of these, 7 to 9 of these commissioners, but 5 of them have to agree. The point is, they were trying their darndest to make sure that when these land disputes arose, and they knew they would, that they were settled in the most peaceable manner, because they knew what had happened in Europe time after time after time, where England or France or Spain or Austria or Russia would take one or the other's little bit of territory, then you get a war. And this would go on and on and on. It goes on all the way up to World War II, where the Germans come in, take French territory that they say was owed to them, you know, from World War I, which the French said was owed to them from the Franco-Prussian War, and which the Germans say was owed to them from Napoleon. You keep going back and forth. We don't know if it would have worked. We do know that the decision to distribute land was greatly enhanced when all of the landed states, those that had land stretching all the way across the country, said, okay, we'll give up that extra land to the federal government. That was a big deal, because some of these states gave up land that would be easily the equal of something like California or Texas if you stretched it all the way across the country. And moreover, it would be a swath of land that people could not transit north or south without going through one of these states, one way or the other, all the time. So we'll see how that works out later. All right, we're going to call it quits here for today. And next time we will pick up on page 31 in the second full paragraph of Article 9. And we are not even a third of the way through Article 9. So I will see you guys back here on Wednesday. Remember, we will not be doing a class on Friday, so I will be at a homeschool convention. Paragraph 2, okay. And remember to check out all the free stuff on Patriots History of the United States, all the blogs. I mean, you have to poke around a little, but if you get into the blogs, you will see all the incredible free stuff. Remember, help me turn this into a movie. Buy Larry a coffee. Watch the trailer and buy Larry a coffee. Okay. I will see you guys back here Friday.